Anthony Apple and the Queen. Would you like to be seated? As we've got appearances,
My name is Saskia and I will serve my co-counsel, Mr. Gina Doe, representing the appellants, Mr. Albert and Mr. Anthony Apple. I will take 2 minutes for introduction, 8 minutes for my argument, and the co-counsel speaking for 3 minutes. We will reserve the remaining time for the vote.
and for the respondents,
Your Honour, if it may please the court, Ms. Gillespie, appearing on behalf of the Crown, the respondent, I appeal with my learned co-counsel, Mr. Rakimi.
sorry, what was that?
Mr. Rakimi.
How is that spelled?
Oh, sorry, Rahimi.
And do you have some time for us?
Yes, Your Honour, I shall speak for 10 minutes and my co-counsel shall also speak for 10 minutes, save 2 minutes for rebuttal, if it please the court. Thank you very much.
Ms. Apple,
Your Honours, today my clients, Mr. Apple and Mr. Anstey, leave to appeal against their convictions on the basis that the evidence obtained by the respondent was done so improperly and should have been stricken from the initial court proceedings. We will consider the circumstances of the footage being obtained, concluding that many other avenues consider the respondents who have taken action without contravening Australian law. I will then draw the court's attention to balancing exercises set out in section 138, subsection 3 of the Evidence Act of 2008 Victoria. It is the appellant's admission that the trial judge ultimately dismissed and failed to balance important factors that exemplify the serious and unlawful actions carried out by the respondents. My co-counsel then employed Your Honour to find the sentence is overtly excessive and is not reflective of our client's actions, nor does the sentence take into account the existence of relevant mitigating factors for the relevant to our clients. The first issue at the forefront of this case is that the prosecution's claim that the trial was factual, that it would have been too difficult to obtain the evidence lawfully. This is an important question for the court to consider, as it helps us better determine the admissibility of the evidence pursuant to section 1383H of the Evidence Act 2008. Naturally, evidence should not be admissible where there are other lawful avenues by which it could be obtained. Your Honours, I would like to draw your attention to the case of Superior Queen 2020, Volume 1 of the High Court of Australia 23. To say briefly, this case relates to a dispute regarding the admissibility of footage that was obtained properly at a breakdown facility in New Wales. Evidence had been obtained for the means secret surveillance, capturing improper conduct in the concentration facility. In this case, the prosecution for deliberately set up secret surveillance in the property argued that obtaining the evidence lawfully would be greatly difficult. At 33, His Honour found an error had been made, the trial judge accepting the prosecution's claim that the evidence would have been too difficult to obtain lawfully without any impropriety. In this appeal, His Honour held that the prosecution's perception and opinion as to the difficulty of obtaining evidence possessed a significant degree of speculation and refuted the trial judge's acceptance of this fact. Therefore, what we can learn from here is that any speculation as to the perceived difficulty of obtaining evidence without impropriety is viewed unfavorably by the court. We agree with the sentiment. We submit the learned trial judge erred in accepting the prosecution's baseless claim that the evidence was virtually impossible to have been obtained lawfully. I humbly request that Your Honours reevaluate the difficulty of obtaining evidence lawfully as required by section 138, subsection 3A of the Evidence Act. My question to the court today is, how is it plausible that trespassing was the only reasonable and achievable method of obtaining evidence that the density of the funds was too great? Does the state of Victoria really have no other avenue that would allow citizens to make claims to animal abuse to be investigated by the appropriate authorities? A such act of vigilance is really necessary and should be really encouraged.
Sadly, can I stop you from there? You seem to be talking about the recorded evidence as though there was only one source of evidence. There was, in fact, inadvertent recording of evidence. What do you say about that?
Right, I thought this part of my submission I would focus on the evidence obtained for the trespassing.
Well, do you say that inadvertent recording is unlawful and should be inadmissible on that basis?
Yes, Your Honour, the evidence of the intent the respondent entering into
we say is trespass, so it's the same.
This one.
Thank you.
In Victoria, the RSPCA is not the sole organisation which claims animal abuse or misconduct of livestock to be reported to. In fact, we have recently understood that it's actually Agriculture Victoria that is the primary authority to investigate claims on livestock abuse. On Agriculture Victoria's website, we have a very easy and straightforward platform where complaints can be made to this authority to investigate. Similarly, if the respondents were so concerned with the welfare of these chickens, shouldn't the Victorian police have been notified? We note the summary of facts that the RSPCA investigated complaints made by the farm in the past. We have no evidence that these complaints were made by the trio who trespassed into my client's property. We also have no evidence to suggest that the trio had made any attempt to contact any other authorities, such as Agriculture Victoria or police, where an official complaint could have been lodged, where a lawful authority could have investigated further. To assume that my clients just denied investigating authorities access to the zones that were restricted to the tourists is mere speculation. When the RSPCA investigated these baseless complaints made in the past, they were shown the usual sort of the farm. However, there is nothing that indicates the RSPCA could requested to observe the density of the chicken cages. When recently the RSPCA investigated the farm following improperly obtained evidence, our clients were open and humbly admitted to knowing that the density was greater than industry standards. And the RSPCA initiated
Ms. Appley, does the RSPCA have the authority to force entry into a place where they have concerns or reported behaviour?
I don't think they have the authority to enforce themselves, but there is no evidence to suggest that our clients would deny access.
And does Agriculture Victoria also have similar rights of access?
They have similar rights to access, but they can also obtain a search warrant. Had the RSPCA initially requested to be the density, no evidence suggests anything out of denied this. This would have the footage being obtained lawfully. To make any claim that clients maliciously concealing the operations of the farm is no more than mere opinion and speculation as to our client's characters. I submitted to the court that when the trio trespassed into a client's property to obtain the footage, they were likely to feel their personal bias against the very existence of the chicken farm, as they could not have known anything about the operations of the farm. This type of practice is not unlike acts of vigilantism, which is defined as a practice of ordinary people taking unofficial action to catch and punish people that they believe to be criminals. Rightfully so, vigilantism is viewed unfavorably by the courts, and so I humbly request your Honours take into consideration the respondents and other avenues available to them, but they could have allowed complaints to be investigated by the appropriate authorities, but by evidence.
The vigilante that's like that, going on the streets and catching the crook, right? And then using force to arrest them or detain them, have they even punished them? None of that happened here. It was to report it was taken. And it's sort of prosecuted by the relevant authority. It's not vigilantism, is it? It's not prosecution by appropriate authority.
I would comment that the autonomous or vigilantes were sent similar acts were like, so that there's a vigilante. They had trespassed into the property, which was an unlawful act. They had done so to do what they thought was to prevent and punish a crime, to catch a crime. Apologies.
Ms. Appley, what do you have to say about the phone call? Sorry, the phone recording. What do you have to say about the phone recording? You've covered the trespass, but what do you have to say about the phone recording where it's captioned inadvertently, or I see that your opponent's submission might say it's something else, but I'm hearing you say that it might be an inadvertent recording, but what do you have to say about that in terms of its impropriety?
They had deliberately handed the footage to the RSPCA. May I use all further counsel?
Yes.
In pursuit of section 138. 8. It states whether the impropriety of contribution was deliberate or reckless. We find that anyway the evidence was deliberate. May I proceed, Chair?
You have about 30 seconds remaining of your time. So if you'd like to perhaps summarise your submissions.
In my second submission, Your Honor, I find it necessary for the court to consider the balancing exercise of the subsection 3. Now knowing that other avenues existed for respondents to obtain the evidence, pursuant to subsection 3 of section 138 of the Evidence Act, it requires the court to consider the gravity of impropriety by which evidence was obtained. Now knowing that there are other methods by which evidence could be obtained lawfully, the gravity of impropriety can be viewed more critically and more weight can be given to this factor. We also need to take into account the whole picture. The respondent's actions were deliberate, as set out in section 3E, but the impropriety was not of insignificant nature, as set out in 3H, so the difficulty was based on the speculation. We can clearly see that the trial judge erred in weighting these factors against the defense of our clients. I therefore implore Your Honor to persuade to reevaluate the balancing exercise of subsection 138, subsection 3, to find that the evidence obtained not been limited on the basis that it was obtained. My precedent should not be so where I want crime to another crime. I will now hand over to Christine for the trial discussion.
Thank you, Your Honor. I would like to say that this is both Alice and Andy's first offense, so on behalf of my clients, I would like to plead for leniency, especially for men with non-intentional actions to commit a wrongdoing again. Alice and Andy have acknowledged their wrongdoings, both in thought and in deed. They feel much shame and disgust by the
I'm sorry, Ms. Doe, your clients didn't plead guilty to the case. They entered in plea of not guilty. How have they owned
This is a airline conviction and sentence.
We submit that following the trial, much has changed about clients since then.
You withdraw the appeal conviction.
Pardon, Your Honor?
You're withdrawing your appeal conviction.
No, Your Honor.
That's
Alice and Anthony have also released a statement on their class website apologizing to animal rights activists and taking full accountability for their offenses.
So where is that evidence in the
I have the information.
if you have it on hand, is it being provided to your opposing counsel?
Good evening, that's all I have.
It's highly unusual to admit new evidence in hearings. It should be provided to the other side months in advance of this hearing.
I'm willing to withdraw that if Your Honor does not want me to discuss it.
Thank you.
Anthony and Alice have also expressed that they would like to take future steps to improve their business conduct. And I would also like to say that in recent years, like most of the agricultural sector, the farmers experienced many hardships due to the COVID-19 pandemic. The farmers lost much income due to staff shortages and also supply contamination, and like most people, the accountants face extremely desperate times, and early acted out of necessity to support their cheap farm.
So, Ms. Doe, are you arguing that we should be lenient or show lenience to your clients because they're having a hard time? That we should excuse extreme animal cruelty because they're feeling a bit bad and not doing so well financially? Is that your submission?
I would like to say these circumstances contribute to the Sentencing Act 2001, Section 5(1)(c), in which one of the governing principles of sentencing are rehabilitation of the offender. And I feel as if these conditions have also encouraged my clients. I think these factors contribute to the fact that my clients have potential for reclamation and rehabilitation.
And Ms. Doe, you've actually reached the end of your 3 minutes of allocated time. Would you like a further 2 minutes to finish your submissions?
Yes, thanks so much. I would like to say that surely prison itself is much too harsh, and if my clients must face imprisonment, and indeed it's entirely excessive, especially when it's instituting potentially neglecting their farm or share so that against reporting. I believe that if these men are given a chance to change, we ought not deny it from them. I also submit that the federal laws of income will not help with their rehabilitation, as they will be unable to spend months in prison, further increasing their desperation. I also ask you, I would like to submit to non-officers such as Albert and Anthony for punitive purposes, also rehabilitative purposes, and to consider their livelihoods and welfare following the completion of the sentence. Perhaps a 12-month sentence is too much, and men will already be punished in that way.
Your Honours, and if it please the Court. Today, we assert that the appeal should be dismissed, and we do so for two reasons. Firstly, the trial judge appropriately applied the Balancing Act in Section 183, subsection 3 of the Evidence Act to the facts of the case, and secondly, the sentence of 12 months imprisonment is a reasonable and appropriate sentence given the facts of the case. That second point will be argued by my learned co-counsel. Firstly, in relation to the application of the balancing exercise in Section 138, subsection 3 of the Evidence Act, evidence that is obtained in contravention of an Australian law, such as trespassing or through an impropriety, can be admitted if the desirability of admitting it outweighs the undesirability. That is the crux of this assertion. We assert that the desirability of admitting this evidence outweighs the undesirability of the trespass. We agree with the assertion that the evidence was obtained illegally through trespass. However, we do believe that the desirability of this evidence to the case outweighs that. Section 138, subsection 3A, when we are applying the Balancing Act, indicates that we need to consider the probative value of the evidence. We assert that the evidence was important to our case, to the case, because it displayed the maltreatment that was happening at the farm, and it also displays the necessity for the warrant that was later granted. Section 138, subsection 3B in the balancing exercise indicates that the importance of the evidence to the proceeding needs to be considered. We assert that the evidence was important as, firstly, it includes an admission from Mr. Ant and Mr. Apple of their guilt. Also, it helps supply. Yeah.
Wasn't this a? This is a private act, so isn't there a right to privacy here?
There is a right to privacy. You are correct. When you say private act, do you mean the recording, or are you referring to the surveillance?
Filming this abattoir. Isn't that recording what's happening on the private premises?
It is. However, I would draw your attention to a specific case, the Australian Broadcasting Corporation and Leader Game Meats Proprietary Limited from 2001, which was held in the High Court of Australia. In that case, it was found that filming, filming processing operations in a meat abattoir was deemed to not cover a private act. It was held to still be a trespass, but it wasn't seen to be a private act because of the nature of those proceedings. So potentially that could be used in our case if we take that forward and apply it to our case.
Does Lena discuss the admissibility evidence on that?
It's not the admissibility of evidence, it's just whether that act of filming in an abattoir is considered a private act or a public act.
So then how can you bring it into this?
We're bringing it in terms of the definition of a private act, as it relates to, that was under the Surveillance Devices Act that they were discussing in here. Alright. Section 138 3D, when we are applying the Balancing Act, we're going to move on to that, talks about the gravity of the impropriety and whether that outweighs the admissibility of the evidence, the value of it. And we would like to assert that a trespass is a summary offence and it is relatively minor, especially in comparison to the ongoing maltreatment and cruelty that the chickens were experiencing on the farm. One of the trespasses, the perpetrators were already on the property when it occurred. it was still a trespass, but they weren't broken in, they were already on a shore when it occurred. So we would like to assert that the gravity of the trespass in this situation was relatively minor, and that it was fairly necessary to be able to get that footage so that these particular applicants, as well as others that are potentially considering similar crimes, could be prosecuted and deterred. Lastly, section
I apologise, Ms. Kinsby, what do you have to say about the trespass that took place in the evening beyond all the signage warning against risk and hazard?
Yeah, I would agree, it is a trespass, Your Honour. I'm not going to pretend that it's not. But I would still say that if we're looking at the gravity of that trespass in comparison to a large number of chickens that are experiencing cruelty, whereas a few people breaking on, not damaging themselves, not damaging anything, if we're balancing them, we would assert that the gravity of the animal cruelty outweighs that trespass.
Ms. Gillespie, how would you address section 138 3F? 3F, given the impropriety of a right of a person recognised by the International Convention on the Civil and Political Rights, a right which is enshrined in Victorian law in the Human Rights Charter, notably section 13 of the Human Rights Charter, which enshrines a person's right to privacy.
Yeah. We're not going to disagree that that was contravened, but we are looking at everything else. It's a balancing act. So in terms of the evidence that we have, we still agree that the probative value and the importance to the case, as well as I'm going to move on in a second to subsection 3H, which is the difficulty of obtaining the evidence legally, all outweighed the contravention of the privacy. Subsection 3H, as I said before, is about balancing the difficulty of obtaining the evidence legally. Now, we assert that it would have been incredibly difficult for the RSPCA to obtain this evidence legally and thus grant a warrant under Section 24G of the Prevention of Cruelty to Animals Act. We say this because the RSPCA had previously applied for a warrant, as well as previously applying for a warrant. They also tried to obtain the evidence required for a warrant legally. They've gone down two avenues. They tried to obtain it at the farm, they tried to apply for the warrant. Neither had been successful. So it might not have been impossible to obtain a warrant, but it was very difficult for them to obtain that evidence legally.
Ms. Gillespie, how do you address the submission of the appellants that relying on the idea in the High Court that it was wrong to assume that difficulty in obtaining imputed evidence would support its admission into evidence?
We assert, Your Honour, that in this case, there was evidence of avenues that were attempting to be followed. They tried it, and I'm also going to jump off the point that was made from our learned friends over here, that their clients, their applicants, would have willingly given over the information if the RSPCA had asked for it. We believe that this is just speculation around this, as the RSPCA had tried, they had gone, and they had never been willing in the past. Alright, if there are no further questions, Your Honours, I'm going to hand over to my learned counsel, who's going to take us through our views on this sentence.
Your Honours, our learned friends suggested that the applicants are remorseful. That is completely false. If that was the case, then they should withdraw the appeal on conviction, and we should save the court time that we are taking up right now. It is the matter of fact that the appellants and their client, that they pleaded not guilty, and therefore there is no evidence that they've been remorseful. On the second point that they raised in relation to the pandemic and the fact that they were forced to somehow abuse and injure animals, there is no relevance in relation to the Sentencing Act. If Your Honours find and uphold the conviction in this matter. The only issues relevant in the sentencing relates to the seriousness of the offence, the denunciation as per section B, 1B, and the past offences and the character of the individual.
Well, I stop you there. There are a number of factors and principles that we must take into account in sentencing. I hear what you're saying about the remorse factor, but what do you have to say about factors such as deterrence? What are you proposing is the most suitable sentence to deter this from happening again?
We submit, Your Honour, that the sentence of 12 months is appropriate in this case. The seriousness of the offence, coupled with the fact that they've breached two of the subsections of the Prevention of Cruelty of Animals Act, amounts to a serious enough crime that would warrant a 12-month conviction.
Why not a fine? Why would you say a fine would serve general or specific deterrence?
Your Honour, we submit that the activity has been going on for too long enough for them to have profited enough from the activities that any fine imposed by this court would not be sufficient to account for the damage and injury that they've caused in the community, and especially in relation to animal cruelty. I will now move on to two other points in the written submission from our learned friends, which was, if I may refer the court to a case that they brought up about drugs and the relevance of that to this case. Again, irrelevant to this case because the charges being laid here are in relation to the Animal Cruelty Act and have nothing to do with the illicit drugs. Your Honour, I will have to bring that up. The case that I'm referring to, Your Honour, is the Ridgeway and the Crown.
Actually, it doesn't really matter what the facts of the case were. It's about the evidence. It's about the Evidence Act, which is uniform act. It's on the point of the miscommitted. So
I think, Your Honour,
sure. It's about sentencing.
That's right.
I think I've got the wrong point. They were talking about it in the context, weren't they, of the disability?
I think that the appellants were relying on that for some sort of claim in relation to manifestly excessive.
You're correct, Your Honour. I think the point that my learned friends are trying to make is to make it to draw a comparison between our case under the Animal Cruelty Act and the case in which a shorter sentence was imposed. Again, the legislation is different.
Mr. Rahimi, with respect to that argument run by the appellants that one would manifest excessive sentencing, are you able to point us to some other case law that might guide the court into whether a 12-month sentence for 2 counts of animal cruelty would be considered to be manifestly unfair? Because obviously the only way that this appellate court can step in the sentencing is if there was some element of manifest excessiveness in this sentence.
Your Honour, I don't have that information at hand, but I'm happy to provide a supplementary submission after this. But the only point I'll probably just make at this point is the fact that there are sentences of 12 months or maximum penalty that have been imposed in the animal cruelty and the prevention of animal cruelty cases, and the statistics are available and I will just draw your attention to some of the statistics that are available through Victorian Sentencing Advisory Council, which was published in 2019. If there is no further question, I might just...
Mr. Rahimi, in relation to sentencing, obviously the maximum sentence available for this crime is 12 months imprisonment or 250 penalty units. Now, the appellant has submitted that their clients have somehow impoverished and a financial penalty would be a significant burden on them. Are you able to tell me what 250 penalty units is at the moment and whether that might also be considered to be a deterrent and deterrent?
I'm afraid, Your Honour, I might have to just seek counsel from my co-counsel, but the issue here is really that the assertion that the appellant is financially impoverished. I mean, they've been financially benefiting from this practice for over many, many years. We submit that they've been profiting from this practice for over 20 years. I'm sure they have a little money put aside for a rainy day. And
I understand it's speculative. We don't have any evidence before the court to suggest that they were profiting nor as to the time frame. So we might move on from that solution.
Absolutely, Your Honour. If I may, I might just move on to the deterrence argument. We submit to the court that the gravity of the offence was large enough that the community expects from this court to uphold this maximum sentence, so that no future instances where animals have been mistreated and sold for financial gain for selfish reasons, might I add, do not reoccur in the future. So I think there is, we do submit that there is a strong case for upholding this maximum sentence, and we submit that that should be the case. If there's no further questions, Your Honours, I will end my argument here.
I believe Ms. Doe, rebuttal. Yes, sir. I would like to draw your attention to the case, which I know has actually been mentioned before. I would like to submit that the Leonard case is part of the civil jurisdiction and therefore must be held to a different standard to that of the criminal case. I would also like to draw attention to a point which my learned friend Benjamin submitted, in which the evidence would have been difficult to obtain otherwise through any other method. I would like to point out the case of Gideon and the Commissioner of New South Wales Division, 2008, 236 Commonwealth Law Reports, 120. May I just have some citation?
Yeah, that's fine.
Thank you. In this case, the police had pushed, or I would say entrapped, the accused into drug possession and therefore charging them with it. In this case, the charges of drug possession, possessing the drugs in which the police had given them were dropped, because that evidence was considered invisible. This case is a positive example of how there are other and more legitimate ways of obtaining evidence of crimes and wrongs of the I would also like to conclude. I would also like to submit that the trial judge had misapplied the balancing act of the balancing test of the evidence act, not properly considering the deliberacy of the deliberacy of populist actions when handed over according to RCCA. That is what
Your Honour, just for the sake of fullness of the argument, that penalty was 4,500 for a maximum penalty units.
Thank you very much.
Did you have a silver button?
Your Honour, if it please the court, we just wanted to point out in relation to the statement from our learned friends over here that the abuse of police powers and admissibility of evidence around that is a bit different to the context of our case where it was evidence obtained by individuals.
Thank you. Well, that concludes the oral submissions. If you would like to retire to consider our decision.
Okay, please report.